I do try to time this. Being human, I'm going to have to skip a small segment because I'll run too much time. So I'm going to jump back in here to home equity lines of credit. This is kind of a fun topic. That's a strange adjective. Okay. So RPAPL 1921 requires a lender to provide a discharge of a line of credit mortgage upon written request. So you have to include a written request to terminate the line of credit and discharge the mortgage when you make a line of credit payoff. Lenders are resistant to closing these lines of credit, so it's really something I'd like to emphasize. Prior to closing, you should also verify that payoff amount after the payoff letter is issued before closing to be sure another advance was not taken. And the step of asking the borrower to freeze that line of credit is also something we strongly advise. So why are we doing this? That's based in RPL Section 281, essentially boiled down to this. Future advances are secured by the lien that is future advances are secured by the lien that is recorded according to the recording date, not the date of advance. And that just makes sense, right? The date of the mortgage is the date of the lien, even though you take an advance years later. For particular language about the written request, there's 3 cases in your materials, 2 of which involve HSBC. You'll find those interesting, and Trustco Bank versus DeNova is also quite interesting on this point. We have numerous claims based on re-advances of lines of credit after the borrower seller has sold the property. As I mentioned, lenders are resistant to closing these, and the seller says, hey, I've still got access to this credit, I'm going to use it. We had a claim scenario where the sale took place about 10 years prior. 2 payoffs to HSBC were made. One of those was a line of credit, and the payoff was made at the local branch. That purchaser from 10 years ago is now selling, and the search continuation shows that the line of credit is still open. HSBC had by then assigned the loan, and when that assignee was contacted, there's a balance of $90,000 owing. Now that purchaser had paid off their first mortgage diligently and was expecting to retire. That purchaser had no owner's policy, so plans were definitely changed. I have another home equity example, but I think given the time, I'm going to maybe save that for lunch if you would like some entertainment. It was a new line of credit checkbook sent to the seller's new home. It's a good one. So. But for now, I'm going to talk about mortgages that appear on the title report not being paid off. Allegedly, they've been paid off in the past, but they do remain open of record. The term ancient mortgage is defined differently in different areas of New York. New York common law requires that 20 years have passed since the due date of the mortgage. On the state level, there's New York State Land Title recommended practices, dividing the ancient mortgage definition to institutional and non-institutional lenders, and also using a dollar threshold. Also at the state level is New York State Bar Association standards of title exam, using a $25,000 threshold and a maturity date more than 12 years from the date of title exam. Monroe County, unlike most, refers to RPAPL 1931 concerning ancient mortgages, which involves a petition to Supreme Court and can lead to a court order stating that the mortgage be discharged of record. There's an interesting 2015 New York Law Journal article on this process in your materials. The Jamestown Bar, Northern Chautauqua County Bar, and Cattaraugus County Bar standards are in your materials. Just generally speaking, those rely on a mortgage recorded more than 50 years ago or a 12-year time frame as to the maturity date of that mortgage. My point is, whatever the criteria, it is often difficult to meet. So most often an ancient mortgage affidavit or no demand affidavit is not appropriate to omit it from your mortgage report. from your title report. So let's hold that thought for just a moment. I'd like to talk about an ancient mortgage where the mortgagee was an individual. Whether that individual is deceased or alive, you can look to RPL 321. A deceased mortgagee who happens to not have a fiduciary. In that scenario, you can have all the heirs sign a discharge as long as that mortgagee died more than 2 years ago. If you have more than one mortgagee, most often not all of those mortgagees have to sign a discharge, whether they do or their heirs. The statute is cumbersome, but when you boil it down, unless the mortgage itself has a statement that specifies the respective interest or percentage of each mortgagee in fraction or sum of money, or describes those mortgagees as tenants in common, or describes the mortgagees that they share equally, right? And those usually are not on your mortgage document. Given that those are not there, one mortgagee can sign a discharge. Or, as I mentioned, if that mortgagee is deceased, the heirs. So back to old mortgages that can't be omitted with that ancient mortgage affidavit, and it's an institutional lender. I have a scenario where we had a 1992 purchase money mortgage with a 30-year term. It was assigned in 1998. That lender went out of business, and the successor lender was ABN AMRO. Mortgagors died in 2022, and the children were selling to a bona fide third party. The children claimed that there were no mortgage liens. They had found no statements or anything indicating a payment to a mortgage lender in the parents' checkbook. So the sale went forward in June of 2023, and those purchasers then applied for a cash-out refi mortgage. That search bring down showed a modification of that 1992 mortgage with City Mortgage, happened to be a successor to ABN AMRO. That modification was dated in 2011, and for whatever reason, there was a huge delay in recording it to August of 2023, a month after those purchasers had purchased. Unfortunately, there was no owner's policy. There was one attorney for both the seller and the buyer, and they had funds in escrow for the recording of a duplicate discharge. I think this one is unusual, but I think it speaks to the point of buy the owner's policy, because you never know. It covers the risk. It's not a whole lot of money. And it also speaks to one attorney representing both sides, what can go wrong. If you don't have a home equity line of credit and you've got that open mortgage, if you can track down the payoff letter, copy of check and transmittal letter, and hold funds in escrow until a duplicate discharge is recorded. These are the companies we have referred our clients to. They're very good. They're very resourceful. This is in your written materials. Whether you do this before closing, which is of course what we recommend, or after with funds in escrow for recording the discharge. In particular, that I think it's payoff assist. If you need help tracking down who a successor entity is to a lender that's gone out of business, they also offer that. You may come across DITEC or Green Tree mortgages in your chain of title, no discharge. There is a bankruptcy court order in your materials that you can rely on rather than getting a duplicate discharge. There's particular treatment for them. And believe me, I don't talk about this stuff if I go to a holiday or cocktail party because people would run away. But it is valuable to us here. I'll speak a few minutes about judgments. What if you have a judgment debtor who was also somebody who had filed bankruptcy and that bankruptcy is now discharged? Is that sufficient to omit the judgment? And the answer is no. The bankruptcy code is section 524. A discharge in bankruptcy voids any judgment at the time obtained to the extent that the judgment is a determination of personal liability of the debtor. So it is the debtor personally that is discharged, not the real property. A debtor's personal obligation to pay a judgment is discharged, but the lien of the judgment of the debtor's property owned at the time of the bankruptcy petition, not after acquired property, but property owned at the time of the bankruptcy petition, that judgment lien remains. And you will need either a payoff letter, or if there is the grounds for it, a court order under 522F, and it would be a court order voiding the lien of the judgment. So we had this scenario. A judgment against one of the owners was omitted from a title report. That judgment debtor had a discharged bankruptcy. The attorney who omitted it didn't see the problem. The attorney for the creditor was watching the land records, started a sheriff's execution about a month after the deed went on record. Thankfully, there was an owner's policy in place. The judgment creditor was paid off. So the more common closing, where the title report states a judgment possibly against the seller, and an affidavit is provided, essentially, this is not me, but somebody with a similar name. We ask that you scrutinize all the information. What is the address of the debtor in that judgment? What is the middle initial, if any? Compare that to what you know about the vested owner by looking at the deed, the contract, the address on the tax bills, and if possible, photo ID. So here's a scenario. We had property was to be sold that was in Oswego County, Constantina. One of the sellers was Tyler M. Leonard. Tyler took title in 2018 and added another owner in 2021. The 2021 deed recited that Constantina address for Tyler. The tax bills showed the Constantina address. A judgment was found versus Tyler Leonard, no middle initial, entered in Madison County, not far away. The action had begun in 2019, and the judgment was entered in July of 2020, and states a Clay, New York address for that Tyler. The transcript was filed in Oswego County. There happened to be a second judgment debtor, not the same person as the additional owner with Tyler. The Clay, New York address is not the same address that Tyler had used when he bought it originally in 2018. It's a somewhat common name, and given the geography and the facts here, an affidavit seemed credible and was provided. The judgment debtor, Tyler, seems to have never lived in Oswego County, but instead seems to live in Onondaga County, where Clay, New York is, and happened to be a defendant in a matter in neighboring Madison County, where the action began. That not me judgment affidavit turned out to be false. The creditor's attorney was aware of Tyler's ownership in Oswego, watched the land records, and after the deed from Tyler was recorded, he corresponded with the purchaser's attorney. Thankfully, there was an owner's policy in place, and our claims department paid that judgment creditor. The agent really, and the attorneys really did everything that could have been done, and reasonably so. I just bring this up as you never know, it does happen. Good idea to get the policy coverage in an owner's policy. The question as to the length of time a judgment is a lien on real property became a debated topic during the pandemic. We all know that a judgment is valid for 20 years and is a lien on real property for 10 years, once it is docketed. And that 10 years runs from the date of entry in original court. Executive Order 202.8 threw that 10-year lien period and a lot of other things into doubt. Was the executive order a suspension or a toll? In 2021, Brash versus Richards was decided in the Third Department and gave us the answer. The executive order was a toll. So if a judgment was entered prior to March 20th, 2020, and docketed, an additional 228 days is added to the lien period on real property. If its judgment was entered November 4th, 2020, and thereafter, and docketed, the normal 10-year lien period on real property remains. We're going to be dealing with this for some time. So I do have just a few points on affidavits, which I think is best to skip to save on time. The point about an agent under a power of attorney not being able to sign an affidavit is in your materials at the Reboul, R-E-B-O-U-L case. It's quite interesting. I'm going to move on. There's our 10-minute break. Okay. Powers of attorney. I'll discuss the powers of attorney in the form itself and use of it to convey real property and recording. Hopefully, the power of attorney a seller will use has been provided to you well in advance of closing. I think you should insist on that if you see a contract signed by an agent under a power of attorney. The form itself, there's been a number of them. From 1996 to 2009, I call that one the old form. From September 1, 2009 to June of 2021, we call that the 2010 form. And the new form beginning June of 2021. Sometimes we are asked if an older power of attorney can be used at all. And of course the answer is yes, provided that it complied with the statute that was in effect at the time it was signed. The current form itself is set forth in the statute, and the statute allows for the POA form to substantially conform to that. The most noticeable change from the 2010 form to what we use now is that the principal's signature not only has to be notarized, but there must be 2 witnesses. And one of those witnesses can be the notary public. I had a call just yesterday where the witnesses were missing on the current form and we could not accept it. Despite that substantially conformed standard, the witnesses are absolutely critical to the validity of the form, so that couldn't go through. The current power of attorney continues to be durable. Of course, that means surviving the incapacity of the principal. And it continues to have the caution to principal language that, again, we consider critical. It has, in terms of substantially conforming, that would be a power of attorney fidelity requirement. The major gifts rider was removed from what we use now. It was on the 2010 form. And the new statute for the current form imposes and lays out some penalties if you unreasonably refuse to rely upon it. So General Obligations Law 5-1501B and 1504 are in your materials as to the principal's signature. It must be notarized and witnessed. Again, the notary can be one of those witnesses. The witnessing is done in the same manner as witnesses to a will, and that's in EPTL 3-2.1A2, and it is cross-referenced in the General Obligations Law. The principal's signature shall be done in the presence of each attesting witness or be acknowledged by the principal to each witness and have been affixed by the principal or at the principal's direction. This can get a little tricky and we won't spend too much time on it. If you've got any doubt about your power of attorney form already signed, witnessed, and notarized, it is a good idea to talk it through with Randy or with one of us. The agent's signature does not require witnesses, but of course does have to be notarized. This can be done on the date of the principal's signature, but not before. So that would be a red flag if the agent is notarized first. The principal can initial the box to allow agents, if they named 2, to act separately. If that's not done, the agents must act together. So that is an important drafting detail. I think when 2 agents are named, quite often one of them is trusted. So to be sure to have the principal make the right initials there. How about the powers themselves? Sometimes we overlook the most important yet basic part. Section F on the current form that has to do with real estate powers in bracket A. That's what we're looking for, of course, in signing a deed. or the parentheses at bracket P, which is I call the catch-all. All powers are granted. We also look to section F for modifications. And on the examination of title side, where a no consideration deed is in the chain of title, we're looking at section F on gifts and G for gifts over $5,000, and on section H for modifications. A couple other points about the power of attorney itself. What if a power of attorney is from another state? General Obligations Law 5-1512 allows for reliance on another state's power of attorney, provided it complies with the laws of that state, regardless of where the principal is a resident. We often get these questions, and either through our own research or Fidelity counsel in another state, we can get an answer to you. When you're recording that out-of-state power of attorney, your county clerk may require a certificate of conformity, so that's a good idea to check on that. If a New York power of attorney is executed in another state by a New York resident, that power of attorney is considered valid in New York. Sometimes we come across military power of attorneys, and that's in 10 U.S.C. 1044B. There are a number of different forms, but each of them starts out with the preamble reciting the U.S. Code, and all of these we have found are durable. These can be relied on. We would not require a New York power of attorney. The military power of attorneys are sufficient. So I think the member of Fresh Start Houses, LLC, that we spoke about earlier, who lives in Florida, is like a lot of people. Let's just use the power of attorney. It's easier. Why not? From our point of view, we just say, not everything's easy, and not everything's supposed to be easy. We really prefer to not use the power of attorney when it is simply a convenience. Of course, use of a power of attorney is necessary based on the principal's mental or physical incapacity. We understand that. So assuming we have that scenario, we keep looking and asking questions. How old is the power of attorney? If it's more than a few years, can the seller's attorney say that it was made as part of estate planning? You know, that's often done. Sign a power of attorney, put it away for use just in case someday. Are you able to compare the principal's signature on the power of attorney to the principal's signature on any other recorded documents? Is photo ID with the signature of the signature available? Is the principal mentally incompetent, and when did that occur? And how long ago was that from when the power of attorney was signed? Remember, the General Obligations Law defines a principal as not only an individual, but a competent individual. Did the principal or agent sign your contract of sale? Does the fair market value, is the fair market value reflected in the contract price, or does it seem very low to you? Is the principal currently living in the property? Or have they been residing elsewhere? Is the principal aware of the transaction, assuming a physical disability only? Will the proceeds be made payable to the principal? And really importantly, is an original power of attorney available? Is the seller offering you an affidavit of full force and effect? Hopefully it's not a scenario where, I only have a copy, the original's gone. There are workarounds, but that's not ideal. As to no consideration deeds signed by an agent, and let's say that agent is also the grantee. We see that in the chain of title quite often, and in that grantee is now selling. Certainly we consider those self-dealing and not in the principal's best interest. So let's say a no consideration deed to the agent was recorded just a year or two before this property's been sold, and the principal has since died. And that agent, who's now, of course, the individual grantee, is selling. We would want to look at the power of attorney itself. Was there perhaps authority to make gifts in it? And was the agent perhaps specifically named as a recipient of gifts? We would also ask about other family members who could possibly challenge this no consideration deed. We'd want to look at the principal's will. Perhaps there was a specific devise in the property. And just knowing who the other beneficiaries are would help us in our risk analysis in this scenario. Sometimes we go so far as to require acknowledged consents from the other family members, or even a confirmatory deed. Whether the power of attorney can be used when the principal signs a deed, does it have to be recorded? So the statute is RPL 294, which is essentially permissive. It says the power of attorney may be recorded. Some county clerks, perhaps back in my day when I was in the clerk's offices, were requiring a power of attorney to be recorded when they saw a deed signed by an agent, but it isn't a requirement, it's a permissive. But turning to the title side, at least for Fidelity, we do require that the POA be recorded. And there's kind of a long-winded answer as to why that is. The power of attorney is critical, of course, to the validity of the deed and the conveyance, that deed being insured, and that being part of the policy coverage. I'll speak to that in another couple of minutes. We may need to see and examine that power of attorney in a claim in the future, and quite honestly, if the title agent's file is no longer available, that's our only resource. But the point is, it's that critical, and we do require the recording. Let's try and move this along so we get to lunch. Policy coverages. So I'm going to talk a little bit about the amended rate manual, which you've probably heard of, and I just put this in as a small part of the agenda, but I'm glad to talk more about this after our break. There are now 46 ALTA endorsements, meaning American Land Title Association. There are 36 TIRSA endorsements, that's Title Insurance Rate Services Association, and that is specific to New York, and that is the 17 underwriters. The TIRSA endorsement is usually modeled on the ALTA, like ALTA is used throughout the country, but it's been modified for New York purposes. Before October 1st, the TIRSA 9 endorsement, sometimes called the comprehensive endorsement, was used pretty extensively. That is withdrawn. In its place are the ALTA 28s on easements and encroachments, the ALTA 9s on covenants and restrictions and private rights, and the ALTA 35s on minerals and subsurface substances, which I don't want to have to say that again. The intent is to remove the TIRSA 9, which was really very broad and all-encompassing coverage, and was frequently too broad for what was appearing on Schedule B. It had the effect of increasing title policy cost. The premium was 10%, not a flat fee. So we like to think that this is a move in the right direction. The no-cost affirmative coverage that you are accustomed to is no longer available. Instead, an endorsement is required, and the coverage in the endorsement does differ. Some affirmative coverages I've read were creative. So now that is removed, and you've got standardized insurance language that has been tested over time and is used throughout the country. If you have a scenario where the title is not marketable but insurable, again, that creative writing in Schedule B and the covenant to reinsure, all of that is gone. It is replaced with the TIRSA, identified risk and identified exception endorsement. Some people are just shortening that and talking about it. They call it the special risk endorsement. I'm not sure that's the way to go. So many of these others are referred to as special risk. So I use the long phrase. Because I think this is of particular interest, I'll spend a few minutes on it. If you have that scenario, whether it's an open mortgage, an open judgment, lack of proof of heirs, no proof of payment of estate taxes, making the title unmarketable, the exception is going to remain in Schedule B, and the risk is going to be filled in on the TIRSA identified risk, identified exception endorsement. You'll see the price there is a little different. than other endorsements, $150 per risk on residential land and $250 on commercial land. That's a new concept in the amended rate manual, by the way. Residential land is 1 to 4 family dwelling. Everything else is commercial, even vacant land where a house will be built. That, because it's vacant at the time of your closing, is considered commercial. So the coverage is for loss or damage provided where the insured loses a deal. You know, they've got a contract and they have to provide marketable title and they can't. This TERSA endorsement is going to provide the coverage. Importantly, this particular endorsement is different than the rest of the policy. It is more narrow. It does not obligate the company to cure the issue, perhaps go out and get a discharge or mortgage or whatever the case may be. And it does not provide coverage for costs of attorney's fees prior to any court order that is adverse to the interest of the insured. Whereas everything else we cover does provide those attorney's fees. That can be quite costly. I think that is a real reason for owner's coverage in the first place. And I understand that this is a bit insurance-y and a bit of minutia, but I think it's an important point as you think about this and think about it with your clients. So there is an exception to this ban on affirmative coverage, and that's a rule in and of itself in the amended rate manual. In these two instances where you have a party wall or you see a right of first refusal or an option recorded in the chain of title, affirmative coverage is available. It is free. It goes on the general endorsement form, and the exact language is all set up in the rate manual. You don't have to do any creative writing. So I'm going to go back to those choices to be used instead of a TERSA 9. We have the Alta 28 series. There are 4 of those. 3 are available on both residential and commercial land, and 1 for commercial land only under development. Of the 3 that you will most likely use, I can really offer to you that it'll be two of those. We call it the 28.1, and that's, I do have a survey at the end to show you a little example of that, fence encroachments and the like. And 28.2, the same kind of encroachments and or easements. The 28.2 allows you to fill in on the endorsement a shed or a barn or an outer building of some sort. The 28.1 is really talking about the encroachment or other issue as it relates to the house. They have split pricing here on the 28, on the Alta 28s. $50 for residential and $250 for commercial. On the loan side, I'm sorry, I'm trying to save time and I'm maybe not doing this justice. Yeah, over here, besides the Alta 28s, we have the Alta 9 series. This is a little more complex. There's 8 of these, 4 for owner's policies only, 4 for the loan policy only. What I think you'll hear most often requested is what we call the 9.3 on the loan side, and it has to do with coverage for covenants, conditions, and restrictions that you see in the chain of title. There's the split pricing at $50 and $250 for commercial property. Okay, policy coverages. I call these items, they're in paragraph 2, the very important coverage paragraphs. What's always been in paragraph 2A, a defect in title caused by forgery, fraud, impersonation, an invalid power of attorney, failure of an entity to have authorized a transfer. That's some broad and good coverage in my opinion. So unless you know the seller, there is risk, and it could fall in any of those categories, and you've got coverage. That coverage really protects the purchaser and by extension, as I said earlier, protects you. You probably have heard about the scheme of impersonation where vacant land is owned. I read something yesterday. It's really increasing in New Jersey. I've gotten calls from agents in Rochester and in Canandaigua on this kind of thing. Everybody's alert to it, but I don't know that there's enough human ability to really detect this. You just have to be on the alert. The point really is if you have a purchaser of vacant land, that owner's policy is critically important. After October 1, they added to covered risk 2A. And if the seller signed a deed electronically and was notarized electronically with Ron, that is now specifically covered. And you might say, oh my gosh, that's never going to happen. And it is. The first one we had to look at was in Delaware County, right? So this is not strictly a New York City type thing. And that Delaware County happened to be vacant land, and the seller was in India, and arranged with this third-party vendor to have the signature on the deed done electronically and notarized with Ron. That you've got coverage for that if you encounter that. Also in paragraph 2 is survey coverage, paragraph 2C. So this is very broad. Coverage by reason of any encroachment, encumbrance, violation, variation, or adverse circumstance affecting the title that would be disclosed by an accurate survey. That encroachment includes things that are your land going onto the adjoiner, and also from the adjoiner onto your insured land. After October 1st, they expanded that coverage to include boundary line overlaps. Woohoo, right? Headline making stuff, but what I'm getting at is the survey coverage itself can be very, very useful in these residential closings. When you read paragraph 2C, the survey coverage, and you also read rate manuals section 2 on rules, the result is on a loan policy only for residential property, you can remove the survey reading exception, and thereby the lender has the survey coverage in covered risk 2C. Schedule B controls, so if the lender insists or for whatever reason must have that survey reading and this shed is located in the easement and they want affirmative coverage, you know, you could argue all day, but if that's what they want, they want. I'm here to say and bring home the point that the better way to go is the broader survey coverage in the policy jacket, no cost, and you can avoid all that back and forth and discussion about affirmative coverage that no longer exists, is now only in the Alta 28. It's different on the owner side. The coverage 2C is in the policy jacket for the owner, but when you read the Tersa rate manual together, the result is there must be a survey exception of some format in Schedule B, and that is what controls, whether it's any state of facts a survey would show or the actual survey reading itself. And there's a few more points on policy coverage, but we are at 12 noon, so I'm going to go ahead and just show you this survey real quick. This is a good illustration of something you may encounter. In the west, in the back of the property, you can see the fence encroachment. And over here on the southwest, you've got the deck and the concrete pad. What we're able to do here is an Alta 28.2 for the lender. We were comfortable giving them coverage that these encroachments would not, well, the coverage, we don't decide. The endorsement covers enforced removal, cost of enforced removal. On the owner side, we would give the 28.1, and that would speak to the existing building, which would be the house, pertaining to the easement that's in front of the house. Just like before October 1, I think I was called stingy when it came to owner's coverage, and it's really still the same approach by the underwriters. And I think this illustrates, we have some choices, and what we can do on the lender side and what we can do on the owner side. you can ask, to advocate for your clients, and we'll, case specific, make our underwriting and risk decision. How about that? 12 noon. Okay, all set. I'm glad to speak with anybody after lunch, during lunch, as we walk down. I appreciate your time. Hopefully there's been a few good takeaways today.